I just want to welcome the people that are logging on right now, and we're going to start in about another minute as we wait for the everyone to log on or take their seats. All right, I'm going to go ahead and start. So I just want to say good morning to everyone and welcome to the Morning Scoop. I'm Gary Grotto, the executive editor of the Arizona Capital Times. And for the next hour, we're going to discuss the opposition to the Voters' Right to Know Act, which passed the ballot in November. Today's Morning Scoop is brought to you by People United for Privacy, a 501c4 advocacy organization founded in 2018 to engage with policymakers at the local, state, and federal level. They encourage elected officials to protect every American's right to privately support the causes they believe in without fear or being harassed, intimidated, or canceled. The Capital Times thanks People United for Privacy for sponsoring this event. And now I'd like to turn to our panelists. First, we have Stephen Shattuck. Stephen is the state director for the Arizona chapter of Americans for Prosperity. Stephen is a third-generation Arizona native who has a passion for politics. Stephen has substantial experience working on and managing both U.S. House and Senate campaigns. In 2016, he served as Senator John McCain's deputy campaign manager before moving to the Attorney General Mark Brinovich's office as Director of Outreach. Most recently, Stephen managed Martha McSally's campaign for U.S. Senate in 2018. And he is the son of former Congressman John Shattuck and the grandson of Stephen C. Shattuck, who managed campaigns for Barry Goldwater and grew up working on his father's 8 successful congressional campaigns. Good morning, Stephen, and welcome to Morning Scoop.
Morning, Gary. Thanks for having me.
And next we have Lee Goodman, who's joining us from Washington, D.C. Lee served as chairman and commissioner of the Federal Election Commission, where he successfully led the rulemaking to conform the agency's regulations to the Supreme Court's Citizens United and McCutcheon decisions and championed free speech on the internet and free press rights. He previously had served as legal counsel and policy advisor to the governor of Virginia and Attorney General of Virginia, Associate General Counsel of the University of Virginia, and General Counsel to numerous political organizations. His experience covers a broad range of policy-oriented subjects, including federal and state campaign finance and ethics laws, First Amendment rights of political speech and association, political action on the internet, taxation of the internet, interstate regulation, and academic freedom. He has extensive experience in all aspects of election administration, having litigated state, local, and congressional recounts, election contests, ballot access, voting rights, late poll openings, and delegate credentials. Good morning, Lee, and welcome to Morning Scoop.
Good morning. Thank you for having me.
And our last panelist is Roy Herrera. Roy is the founding partner of Herrera Arellano LLP, a boutique litigation and government affairs firm with offices in Phoenix and Washington, D.C. In his practice, Roy advises candidates, nonprofit organizations, PACs, elected officials, government entities, corporations, and labor organizations on election, campaign finance, and nonprofit tax law issues. Roy's candidate representations have included serving as counsel to President Joe Biden, Senator Mark Kelly, and Congressman Ruben Gallego. In addition, Roy has represented ballot initiative and independent expenditure campaigns in numerous jurisdictions nationwide. Finally, Roy has regularly represented clients in constitutional voting rights and redistricting litigation, including serving as the Democratic counsel to the Arizona Independent Redistricting Commission. Prior to private practice, Roy served as an assistant United States attorney for the District of Arizona. And as a federal prosecutor, he prosecuted drug trafficking, firearms, immigration, and white-collar fraud cases. Prior to joining the Department of Justice, Roy served on the legislative staff of U.S. Congressman Ed Pastor in his Capitol Hill office. In that role, Roy focused on the passage of the Affordable Care Act and the Dodd-Frank Act, as well as appropriations matters. Thank you for joining us, Roy.
Thank you very much, and I apologize for how long that bio was.
Well, you got quite a resume. So before we get started, I'd like to let the audience know that the chat is open for you to submit questions. And if you submit questions, please phrase them in a civil and polite way, and please don't use the chat as a forum for your own ideas or your own views or chatting with other audience members. And one last thing, a little disclaimer, the Arizona Capital Times does not take a position on the issues we're discussing this morning, and the views and comments are those of the panelists themselves. So let's go ahead and get started. Let's start with you, Roy. So can you just tell us about the Voters' Right to Know Act, how it came to be and what the law does?
Sure. Well, first off, again, Gary and Capital Times, thanks for having me, and also to my fellow panelists. I think this is going to be an important discussion. We may have some differing views on some of this, but it certainly is a huge development in Arizona campaign finance law. And as the title of this seminar indicates, this could be something that is a model or perhaps part of efforts elsewhere. So I think this is an important discussion. But to answer your question, how we got here was that last November, over 72% of Arizonans voted yes on Prop 211, which made and put Prop 211 into law. So now Prop 211 is part of Arizona statute. We're at a position, I think, kind of a transitory position where we're trying to figure out what exactly does it all mean, and how is it that you comply with the new regime. Now, I think, when you look at what happened last year at its very basic level, I think the proponents of Prop 211 would argue that the point to this was to bring transparency and donor disclosure requirements into the world of political expenditures, into the world of political spending. And of course, this was seen as kind of the anti-dark money initiative. And I think at its core, that's what this initiative is trying to do. Now, the initiative is complicated. There's a lot of sections in the initiative related to donor disclosure and reporting, record keeping, ad disclaimers, enforcement for all that. I'm not going to go through all of it because that would probably take 2 hours. But I do want to go through some of the main pieces. And some of it is a little dry because it's pretty complicated, but I think it's important kind of from a table setting perspective for all of us to know sort of what it is that we're talking about. What is the subject of the litigation? And of course, how does that fit in the sort of general First Amendment jurisprudence potentially, which I'm sure Lee will talk about a lot. But first of all, again, what this is designed to do is to create a statutory regime where the source of original monies, and we'll get into what that means, is disclosed. And these are original monies used for partisan political activity, for public communications to support candidates, or anything, essentially spent in support of those efforts. Now, the initial question I think we have to ask ourselves is who is actually covered by the new rules in Prop 211? And that is basically defined in statute now as covered persons. And so when we look at the statute now, only covered persons actually have to comply with the law. Now, the question is, what is a covered person? Well, just reading from the statute, they are any person whose expenditures or receipt of in-kind contributions for, quote, campaign media spending in a given election cycle collectively exceed $50,000 at the statewide level and $25,000 at a local level. Now, there are two things to unpack there. One is to become a covered person, you have to get to a particular expenditure threshold or receipt of an in-kind contribution threshold, but also that has to be done related to campaign media spending. And I think when we get to campaign media spending, that's where we get to, I think, some of the sort of biggest debates over what Prop 211 actually means, because the definition of campaign media spending is pretty broad. I mean, one, it applies to both candidate-related spending as well as ballot measure spending. And the statute sets forth a number of categories of what is campaign media spending, but even that is a little unclear. And so I'm going to go through a couple of them because, again, they are the subject of the lawsuits that Stephen is going to go into afterwards, and we'll all opine on. But I think it's important to unpack. So the first category of campaign media spending is paid public communications that expressly advocate for or against a candidate. That's a pretty obvious category. It exists currently under Arizona law. It's basically your traditional independent expenditures. I don't think anyone has any real questions about that. But then the next category of campaign media spending is public communications that promote, support, attack, or oppose, one, a candidate within 6 months preceding an election, or two, the qualification or approval of any state or local initiative or referendum. Now, that's an important category, and I think the question with that category is, what does it mean to promote, support, attack, or oppose either a candidate or a ballot measure? That could theoretically be a pretty broad category. We don't have any definitions of what those things mean in the statute. The Clean Elections Commission has indicated they are not going to provide guidance in that area. So again, from the practitioner's perspective, which is how I'm approaching it, I don't have any interest in the lawsuits themselves, but from a practitioner perspective, as I'm advising clients, that's one of the questions. What does that mean in this category? The third category.
Sorry, Roy, has the Clean Elections indicated why they don't want to enforce or define, make those definitions?
So we're at a position now that's it's kind of interesting. The Clean Elections Commission has issued some proposed rulemaking, mostly related to the ad disclaimer requirements, which I'm not going to spend a lot of time on, as well as the opt-out notices, which I will mention in a moment, which is the notices that you would give to donors. So we've seen some proposed rulemaking there, but they have not gone further in some of these other categories as far as giving us guidance on campaign media spending or giving us guidance on identifying original monies, the original source of monies. They haven't gone there. Now, I don't know why. Maybe that's going to be the subject of rulemaking down the road. Maybe they are waiting to see sort of what happens with the litigation that's pending. Maybe they never do that, and that's sort of what happens. But again, since I'm approaching this from a practitioner perspective, these are the kinds of unknowns that I think would be appreciated. Some answers would be appreciated. We just don't have them. So going forward, the third category of campaign media spending are paid public communications that refer to a clearly identified candidate within 90 days of a primary election until the general election that are disseminated in the candidate's jurisdiction. That's a category that's similar to what under the federal regime are called electioneering communications, except under the federal regime, that's limited to broadcast communications. Here, that's paid public communications. That's much broader, right? That's not just TV ads. That could be much broader than that in this particular category. Then we get to the last two categories, which I think are, one is certainly the subject of one of the lawsuits, and then the other is also introduces some ambiguity. The fourth category is activities or paid public communications that support the election or defeat of a candidate, including partisan voter registration, partisan get out the vote activity, or other partisan campaign activity. The question in this area is, what does it exactly mean when it refers to partisan? What's the standard for determining whether a communication is partisan or not? Is it as simple as saying, Democrat or Republican, or at least for now, no labels, since they're all recognized political parties in Arizona? Or does it mean something broader than that? I think that's the real question, including this phrase, other partisan campaign activity, which is a kind of catch-all at the end. That is something we just don't know exactly what it means yet. And again, it's sort of the lawyers trying to do their best efforts to provide the best guidance to candidates or to clients, but we don't have any definition. And then the fifth and final category in this area are basically research, design, production, polling, data analytics, et cetera, conducted in preparation for or in conjunction with any of the prior categories, regardless of whether such activity results in paid communications. So the question in this category is, does this include what we would call like retroactive expenditures? So one can imagine a client, an organization paying for a poll. They have no intention that poll is actually going to be used for campaign media spend later. They just want to know, for example, what the public thinks about something. And then 6 months later, they decide to use whatever is in that poll to inform their public communication. That's a campaign media spend. Does that report that you would have to file associated with that include the preparatory costs, the cost for that polling? a reading of the statute, probably, I think the correct reading would say yes, that you would have to include that sort of retroactive spending. So that's in this category as well. There are a number of things that are not included, specifically not included, excluded from campaign media spending. So for example, nonpartisan activities intended to encourage voter registration and turnout are not included in campaign media spending. Also implicitly issue advocacy, which is something that a lot of 501c4s do, are not included within this campaign media spend. But again, I think this is where, as we go forward and this gets implemented and we go into this next election cycle, this is where I think a lot of the battles will be, a lot of the analysis will be that attorneys will give to their clients on whether this falls within the non-campaign media spend category of nonpartisan activity or issue advocacy, or does it fall within one of these categories of campaign media spending. That's going to be the sort of like where the rubber meets the road in a lot of these communications with our clients on what this means. And remember, this is important because you have to reach this expenditure threshold of $50,000 or $25,000 of campaign media spending in order to become a covered person, in order to, again, have to follow the law, to have the law actually applied to you. So that's why this definition is so important. Before I get into the reporting, I don't know, Lee, Stephen, if you have any comments on campaign media spending or any of that, because that is certainly something that I think is at issue in the litigation.
So, Stephen, he mentioned your lawsuits. Tell us about, or your lawsuit, I should say. Your lawsuit. Why did you bring it, and I guess what's the status of it so far?
Sure. Well, first, I want to start by thanking Gary for having us on and Capital Times, along with Roy and Lee. It's always a pleasure to be on, especially early in the morning in Arizona when it's still cool out. So. We did bring a lawsuit challenging Proposition 211. There are currently, as you mentioned, 2 lawsuits. The lawsuit which Americans for Prosperity Foundation filed is a federal lawsuit. There's a separate litigation going on right now at the state level. Both of those lawsuits challenge different components of a state constitution for the state case and the federal constitution for the federal case. In this case, for Americans for Prosperity and our foundation, we believe that 211 violates an individual's right to free speech, which obviously is an extremely important individual liberty. And the reason we brought this challenge is that Proposition 211 proposed one thing and it delivered something entirely different. The proponents claimed it needed to stop dark money, and that defines as people trying to hide behind giving to political campaigns, and then through intermediaries, then giving to a campaign effort. Currently in Arizona and at the federal level, laws already exist that protect those same things. So one, it's duplicative, but two, and most importantly, it violates an individual's right to free speech and also an individual's right to privacy. I think the key components that we'll probably discuss here are, one, the nuances of the actual law. And when you look at the initiative itself, I think voters signed up for a gym membership, and it turns out that they didn't read the terms and conditions, and a lot of the devil is in the details on this issue. And this is going to affect more than just political nonprofits. This current initiative, and as it stands in law, will affect nonprofits ranging from different healthcare industries all the way to humane society. Any nonprofit who is 501c3 or 4, which is also up for discussion around that, could potentially be on the hook for disclosing their quote original source. And the question is, what is the original source? And I don't want to get too in the nuances right now on kind of walking through what that looks like from the perspective of, if an individual donates to, say, Goodwill, and Goodwill donates to another nonprofit that then contributes to some form of campaign spending, then that original individual might not have ever intended for that money that they contributed to Goodwill, for example, to be spent advocating for an individual or for a policy issue. And that in there kind of really affects why we're driving the fact this is unconstitutional, because if you look at the core of our country, and we were really set up for. It's focusing around the ability for an individual to contribute funds and advocate freely for whatever policies they view fit their ideology, and they shouldn't come under any scrutiny. That's the beauty of America, right? We have the ability to live free and to practice free speech, just like the media does, right? I think that's what makes America so great. So we feel this is a very intrusive initiative in law that really does overstep and violates probably one of, if not the most important individual right that an American has.
When you have to disclose, what information is going to have to be disclosed? Just the names, or is it going to be like if I want to just give money to the guy running for mayor, where I have to have my, address and place of employment and so forth?
Yep.
What's going to be disclosed?
So under the law, it currently calls for the individual's name, first and last name, employer, place of employment, and then also I think there's the residency. And so if in that case, let's say an individual is a private contractor and they have several sources of income, then they would have to probably disclose those original sources of income potentially. And so it will severely limit someone's right to privacy. If you get down to it, I mean, why do we need to know where somebody lives who contributed to, let's say, an effort that advocates for, creating a commission for elections? That's a very nonpartisan issue and on its face. And I think if you really get down to it, looking at the intent of this, it really does violate an individual's privacy and also their right to kind of safety. They no longer can be in their home without fear of someone coming knocking on the door asking about a donation they gave to an organization that they actually didn't know was going to advocate on a policy issue.
Gary, can I add to that a little bit to answer your question? Sure. Just on the mechanics of the reporting. Again, some of this is all brand new, obviously, but the Prop 211 has a particular reporting regime for donors. What it says essentially is that if you're a covered person, which I talked ad nauseum about, so this applies to you, and you spend a certain amount of money on what are called traceable monies, and again, it's the $50,000 and $25,000 expenditure threshold, then you have to file a disclosure report within 5 days of that expenditure or receipt of in-kind contributions. So then the question becomes, what are traceable monies? And what 211 does, it sets up this opt-out system, essentially. So what traceable monies are defined as under 211 are funds given to a covered person for campaign media spending for which no donor has opted out for their use of this purpose, or their use for this purpose. So basically, you ask a donor under this regime, you've given me money, this money could be used for campaign media spending, which would mean that you're revealed, your identity is put in a report. Do you opt in or do you opt out? You could opt out, right? I mean, if you get that receipt from whoever you're giving money to, and you say, no, I don't want my name to be actually reported, then you can opt out. But what that means then is that your contribution is no longer a traceable money, which means that the recipient of that money cannot use that money for campaign media spending. So that's kind of this opt-in, opt-out system that this creates. Now, if you're a covered person and you're going to file a report because you've reached the expenditure threshold of traceable monies, like Stephen says, you file a report. This report has information about yourself, of course, as the covered person. But then importantly, there's two aspects to the report: the identity of each donor of original monies or in-kind contributions for campaign media spending totaling over $5,000 over an election cycle. And then secondly, the identity of each person that acted as an intermediary that transferred traceable monies of more than $5,000. And this is where you get to at least a two-step disclosure process. So what that would mean is that you file this report because, again, you have to, you reveal the donor that gave you traceable monies of over $5,000 or any intermediary related to that particular traceable money of over, and that transfer was over $5,000. And those are who you report on your reports. And again, that's after, a person has chosen to opt in or opt out or whatnot. I mean, you have to give them that opportunity. And then you get to the point where whether you have to disclose them or not, and that's over $5,000 or not. So that's the brand new thing here, where you will see donor disclosure for intermediaries and donors of traceable monies over $5,000. And I know in the litigation, the argument's been made that this is a violation because of a constitutional violation, because if you're a donor and perhaps there's an intermediary, you didn't intend for your contribution to be linked to a particular campaign media spend by the covered party. Now, I think there's counter arguments to that, which the Clean Election Commission makes. And obviously, I'm going to have a different view, and I know we'll get into the details about the lawsuits. And Lee, also as an expert, I think I have a slightly different view of whether this Prop 211 actually violates the Constitution. I don't think it does, but in a post-Citizens United world, and we'll talk all about that, but I think it's important to set forth like that is the sort of reporting regime that you have in 211. Now I'll shut up.
So, yeah, and I want to go, talk to, in a few minutes, talk to Stephen about the opt-out as well. And, but Lee, you've been sitting there patiently, and, this lawsuit's going to be litigated within the confines of, as you told me, decades of jurisprudence on freedom of associational privacy and government compelled disclosure of funders. And I'm sure you could teach a whole semester on that. But can you tell us how we got to where we are in the law now, and how it's going to relate to this to these lawsuits?
Sure. One person's dark money is another person's profoundly important First Amendment right. And there are two lines of important jurisprudence that are implicated by Proposition 211. And although the people acting as a legislature adopted it overwhelmingly, that doesn't mean it was constitutional. And so Stephen's lawsuits will prove that one way or the other. But let me give you a little context for the sort of the history and the importance of how important these free speech and free association rights are. I always start this with a sort of a concept, which is that in 1859, John Stuart Mill wrote a famous treatise called On Liberty. And he talked about how in a democracy, cultural majorities use their democratic power to impose orthodoxies on minorities. And historically, in ecumenical fashion, we've seen the right use compulsory disclosure to expose people, vilify people, and try to chase them and their ideas out of the public square, using government-compelled exposure as the cudgel or tool to do that. We've seen it right versus left, and we've seen it left versus right. It is just sort of a natural inclination of those in power, whoever they happen to be, to go after their ideological enemies by forcing them to name the names, which is a phrase that comes out of the Red Scare, to name people, identify them, say where they live, and then use public pressure to go after them and expose them to social vilification, economic boycott, loss of jobs. And you can look at the Red Scare and what happened to Hollywood writers. They were subpoenaed by their government to come name the names of their fellow travelers because they committed the cultural sin of infusing liberal ideology, socialist ideology in movies in Hollywood. Well, the First Amendment jurisprudence got litigated in the late 40s and early 50s and started gradually gaining traction in first dissenting opinions, then concurring opinions, and finally, in 1958, a unanimous decision of the United States Supreme Court in a case called NAACP versus Alabama that said that the government of Alabama could not compel the NAACP to reveal all of its funders in order to do business in the state of Alabama. As a condition of doing business, the Alabama powers that be wanted the NAACP to reveal all their donors. And then if you fast forward over the years, there were other important touchstones in this jurisprudence, some involving the right to associate privately, that's the NAACP case, the right to give your money to associate people who share your ideas is an associational privilege and right. And then, of course, there was also a parallel track about the right to speak and to spend money to speak anonymously without having to say who I am. And that was started in a case called Tally in about 1960, and then it continued in a famous case called McIntyre v. Ohio. There was a Jehovah's Witness case as well about passing out pamphlets. So over a period of about 50 years, culminating in a 2021 decision out of the Supreme Court called Americans for Prosperity Foundation v. Bonta, where the Supreme Court reaffirmed and clarified this right of associational privacy. There has been a well-recognized right to both associate privately and to speak anonymously. And there is one stark exception to those general rights, and that is the area of campaign finance. If you're going to give money to a candidate or spend money to say, vote for or against certain candidates, the Supreme Court in Buckley v. Vallejo, a Supreme Court decision in 1976, said that the government can compel the disclosure of donors and speakers in that limited context where you are expressly advocating the election or defeat of candidates. And that has always been tied to the notion that your spending or your contributions are for the purpose of influencing an election. And I think that's where we are here with the discussion about Prop 211, the Voters' Right to Know Act, and whether it properly draws a clear enough line and an appropriate line between campaign and election influencing speech and association versus issue speech and speech about public officials that is not intended to influence an election, and a fundamental right to petition your government and to speak about public officials, even if you do so anonymously.
I'd like to throw a question at you, Lee, from the audience. He said, if you're talking about contributing to public campaigns, then why shouldn't we know?
Well, if you're contributing to a campaign, a candidate's campaign, if you're contributing to a political action committee that exists for the avowed purpose of influencing elections, if you're donating money to a political party that exists to influence elections, then yes, the Supreme Court says the public has a right to know for the purpose of preventing the corruption of politicians. But if you're giving to a nonprofit organization, and all that nonprofit organization wants to do is to speak about issues in the democracy, and the politicians who are associated with those issues, without any election message, without any message about electing or defeating, supporting, opposing those candidates for clearly for a re-election, then that's where your First Amendment right exists, and you ought not be chilled in the exercise of that First Amendment right. And that's the question about whether or not the standard in this law called PASO is what we call it at the federal level. Roy said that the local election officials don't appear eager to provide clear guidance on what the trigger under this law is. This promote, attack, support, oppose. We called that the PASO standard when I was at the Federal Election Commission, because it has a very limited use in federal law, not for all citizens, just for state political committees and state political parties. And I can tell you, you will not be able to get a clear definition of that standard, because I had to apply it at the Federal Election Commission. And I can tell you some very poignant cases where 6 commissioners, Democrats and Republicans, could not decide whether or not a particular communication promoted, attacked, supported, or opposed a particular candidate. And I'd be happy to go into some examples, but it is an unclear standard, and the mere mention of a public official within 6 months of an election is swept into this law, and it may have zero relationship to an election or to re-electing or opposing that person for re-election.
Would you mind sharing at least one example?
Well, let me give you one. What happens when someone takes footage of a candidate speaking and plays that footage on a screen in an ad? Is that promoting that person or opposing that person? Now, let's say that that person speaking in his own words is saying something very controversial, and I play it to an audience that may have a positive response to it or a negative response to it. I add none of my own editorial content to the replaying of what this public official has said. Is that passoing that person, that public official? We couldn't figure that out. We said there's no editorial input from the actual sponsor of the ad. I can tell you what my guess was. My guess was that they wanted to feature this public official in his own words saying something that might be unpopular. But he said it. Presumably, perhaps it promoted him and supported him. But those who saw it might think, oh, I'm so opposed to what he had to say, speaking in his own words, it must attack him and oppose him. And so you can't neatly put a lot of speech into one of these rubrics of promoting, attacking, supporting, opposing. Now, that standard passo was upheld under a facial constitutional attack in the case of McConnell v. FEC. But that left open any number, an infinite number of potential as applied challenges that in any given case-by-case circumstance, it might be unconstitutional. And it was never intended for wide application in the federal law for the disclosure, for triggering the disclosure of all citizens who might want to speak about policy. It was merely applied to limit what state political parties and state political committees, PACs, could do with respect to federal elections. And so now people have wrenched that standard, which applied to avowedly political groups, and now they're applying it wholesale across all citizens and all ideological organizations and nonprofits out there. And they're trying to now apply a disclosure, a compulsory disclosure scheme or regime to all citizens under this vague standard that even the Federal Election Commission often punted on and could not apply in an individual case.
Gary, can I chime in on that?
Yeah.
Yeah. So Lee did a great job of, I think, outlining the conundrum that I think he probably has with his clients sometimes, and I do certainly, but trying to advise them on, whether a particular activity or public communication falls within the standard or doesn't. And that's going to be the challenge going forward here in Arizona with this particular law, assuming that it stays on the books. I think, Lee's description of, again, the sort of the application of the First Amendment on campaign finance was well done, in that we are in this world where there is this, and this is kind of turning to the federal case as well as the state case that are active here. We're in this world where since Citizens United, and even in Citizens United, the courts have seemed to bless this idea of robust disclosure requirements in a campaign finance context, that basically there's enough of a government interest in transparency to make that okay. Now, Lee mentioned the Americans for Prosperity Bonta case. I think the question in the federal case is going to be whether that case, that Americans for Prosperity case, extends into the campaign finance world or not. So there's been an exception in the campaign finance world for the kinds of principles that the court, described in that case. But again, there's been a exception for campaign finance. The success, I think, of the federal case is going to rely on whether that's changed at all, whether somehow the disclosure regime in Prop 211 is different than the types of disclosure regimes that have been blessed by courts in other jurisdictions. Because like I said, there's a lot of other jurisdictions that do have some disclosure requirements that courts have said have been constitutional, again, for the reasons that Lee outlined, preventing corruption and, the idea that government interest and transparency is enough for that. But again, that goes back to, we're going to see this federal case litigated. There's very good litigators on both sides, for the plaintiffs and defendants, and it's going to be a fascinating case going forward. The state case we haven't talked much about. I think, and this is my personal view, that probably has less likelihood of success, just kind of given what I saw in arguments over the preliminary injunction motion, and then kind of the allegations that are in that case. But this is where we are. The last thing I'll say is Lee kind of mentioned facial challenges versus as applied challenges. I think to the extent that there's going to be anything successful, and I'm not endorsing this, but if there's any lawsuit that's successful against this, it's going to be an as applied challenge from my perspective. And I think that's going to really depend on the plaintiff and the kind of case they make about whether, speech has actually been chilled or not. And I guess we'll see that going forward. So turn it back to you.
Now Bonta it's not an elections case, correct? It has to do with
Not a campaign finance case.
or I'm sorry, yeah, let's put it all in one, in a campaign finance case.
Yes, Gary, you're right. Bonta was the state of California's indiscriminate demand for the donor list of all nonprofit organizations that wanted to solicit contributions in the state of California, and was not a campaign finance case. Roy asked the question, whether or not the Bonta decision reaches into Prop 211, because Prop 211 ostensibly is trying to get at electoral speech. And I suppose that the plaintiffs against Stephen's team out there is also going to try to argue that Prop 211 reaches too far in what it regulates, such that it crosses the line into Bonta, because it regulates issue speech under this PASO standard. And at the federal level, by the way, there is your law regulates not only this speech that promotes, attacks, supports, opposes, what we call a PASO standard within 6 months of any election, which with primary seasons probably extends almost to the beginning of the year of an election year, but also within 90 days of a primary election. So that's pretty much of the election year. But at the federal level, you only require donor disclosure for organizations that make electioneering communications. Those are ads that merely mention a candidate. Don't have to promote, attack, support, or oppose, merely mention them. But you only do so within very tight time frames of an election. And you only require disclosure if the contributors gave the money to the spendor, the organization, for the purpose of supporting those expenditures. So there's an earmarking principle in the federal law of electioneering communications. However, your Prop 211 goes far beyond, does not have an earmarking principle. It requires this affirmative opt-out that may have occurred or may not have occurred a long time ago. And so there is no binding principle here. Everybody who gave, whether they intended or not, is going to be disclosed unless they opted out. And that is what distinguishes this from the current jurisprudence in the area and what's going to be new about the Arizona litigation.
Yeah, and Gary, if I just may follow up with Lee's points there. Some of the comments that are in the chat here, I want to make sure that the individuals and listeners chiming in understand that there's a difference between what 211 does and what campaign finance laws currently enact from the federal level and the state level when it comes to candidates themselves and the direct contributions to those candidates by individuals and what those candidates do with those funds. That is not what 211 does. And there's a question about, why do I think that the voters overwhelmingly supported this initiative? On its face, I think many voters felt as though this would dig into those disclosures. And it's easy for us to get caught up in the kind of the details of the current law as it stands. And if you look at, we have two very qualified attorneys here who know their stuff. And I think they can both agree that it's hard to agree on one issue in this current initiative and its definition of it. And so when you look at the bigger picture here, what our challenge from AAP is that if you look at an individual's right to privacy, I'm going to give you an example of what 211 actually does. And if you look at what it was proposed to do, what it was proposed to do is pull back the veil on dark money on nonprofit organizations. Well, under the initiative, as it is written, if an individual donates to their church $50 per week for 2 years, and that church then donates to an organization that advocates on policies affecting, let's say, homelessness in ways that trigger the statute, that would mandate the parishioner's identity be publicized. This is an issue of an individual's privacy, and that's when people ask me, why are we challenging this? Do we not, believe that the Arizona people are competent and able to vote for initiatives that they support? Absolutely. The problem is that this initiative was sold as something that it's not. This initiative was sold as something that violates our individual right to free speech and our individual right to privacy. And it's important that as America's Prosperity Foundation and other organizations who are partisan and nonpartisan, this is a broad spectrum across all sides. It's important that as Americans we protect, and as Arizonans, we protect individuals who have no idea that they're getting engaged in a political effort due to the actions of a nonprofit organization that they contributed to, that then contributes to the campaign spending effort.
Okay. I got a question here from the audience. This is an anonymous attendee, but they said, I'd be interested in Roy and Stephen discussing all these unanswered questions, being a great example of why this issue shouldn't have been voted on by citizens and quote unquote voter protected. You mentioned that, on its face, it seems pretty simple, but
So I can start on that.
Yeah.
So first of all, in the interest of full disclosure, I voted for the measure, right? I'm a Democrat. This is something that I'm in favor of. If you ask me, Citizens United should be revisited on, whether we can have restrictions on campaign spending. So I obviously have a different personal political perspective. So leaving that aside, though, the way I think I was approaching the description earlier was related to, again, what does a political law attorney do in advising their clients on how to comply with this, in which, in that scenario, there are a number of unknowns. Now, some of that is, and Lee is more of an expert than me, but with his long distinguished career, certainly on the FEC. But part of this is that all of this area of the law is very complicated. It always has been. We as practitioners, as election law attorneys, I think do our best even prior to Prop 211 to advise our clients in a somewhat unknown world. So I don't want to oversell the ambiguity, because I think the ambiguity is, kind of going to be there by the very nature of this area of the law. I think my perspective, though, is that as we go forward and this gets implemented, and whether we find out whether this can be administratively implemented over this next election cycle, a lot of those questions, I think, are going to get answered one way or the other, right? They're either going to get answered through the litigation that Stephen's organization is undertaking. They're going to get answered by the Clean Elections Commission, or if, at some point when compliance becomes possible, they're going to get answered by complaints that are getting filed, right? Because there's an enforcement mechanism to this. And so people are going to actually, if you don't comply, be facing complaints. And through that process, maybe we get some answers. Again, that's a somewhat separate question than whether the ambiguities or some of the requirements go too far in a way that's unconstitutional, which again, Judge Silver, I don't envy her, at the District Court of Arizona is going to have to answer in the federal case.
Yes, so I'm happy to kind of speak to this. If you look at the Arizona Constitution and how it was drafted, citizens of Arizona have the right and the ability to propose a ballot initiative. This was designed originally when the state was founded for the everyday individual to have a voice if they feel they can gain the support of the community and the state around an issue that they feel affects them one way or the other. You have a separate entity, which is the Arizona State Legislature, which the people of Arizona elect. Both of those are capable of technically passing laws. This is a ballot initiative that, quite frankly, this I don't think it's an opinion, because if they were to run this initiative at the state legislature, it wouldn't pass. And that's why they ran it through a ballot initiative. And the problem is that is fine, except for the fact that the initiative process in Arizona, again, going back to its foundation, was founded to give individuals the ability to propose legislation and run it on their own if they get enough signatures to collect it and put it on the ballot. The problem is we've had a lot of organizations who now are entirely focused on running initiatives that pass these types of laws because they can't get them to a state legislature, and they put a bunch of money behind them and allow to essentially work through the fact that there's 100-word disclosure in any ballot initiative they get to give. If you read that 100-word description, and then you go on to read this initiative, you will see that all the things we're discussing in here is not discussed in that 100-word provision. And so that's where a lot of people understand that, look, on its face, that's the 100 words. But the reason we have this in Arizona is because this is a piece of initiative that is so complex that I would argue that it really would require a state legislature to look at it. And if it's not, then we need to look at a different type of law that allows us to educate Arizona citizens on the full piece of initiative and not just the 100 words, because it's misleading.
Now, there is a provision that says the legislature, the counties, and city governments can enact and enforce even more stringent disclosure requirements. Did I read that correctly, or how would that? Can a city council just create more stringent restrictions as what's in this Prop 211?
I'll let Roy follow up with me, but I think that depends on the issue at hand, right?
Okay.
And whether or not it's a local municipality, and is there a question around the campaign spending? I think there's a lot of questions that would need to be answered by the Arizona State Elections Commission, and probably need a better scenario in order to kind of answer that question.
Yeah, I mean, I'm familiar. In other words, I've seen that language. I haven't spent a lot of time thinking about what that means. I mean, I suppose that would mean that a local municipality could pass something that's even more onerous, let's just say. But then I think if that occurred, we'd be kind of in the same position where we'd see a potential legal challenge. And I have to imagine none of the local jurisdictions are going to do anything like that until we get some answers from the federal or state case that are currently pending at the statewide level.
Now, Roy, we spoke a little bit beforehand about the laws in effect, but we're in kind of a twilight zone or in a lull here as far as enforcement and compliance and all that.
Well, some of it has to do with, again, yes, to answer your question, we're kind of in an in-between stage here where the Clean Elections Commission hasn't actually issued formal rulemaking yet. There's just proposed rulemaking. So they've got to do their job, and they will, as far as what rules they're going to adopt related to this. But then even things like the actual process for filing reports, which would be required by covered persons. There's no platform for that. There's no way to do that at this point yet. So I imagine that's all going to come later this year. But at this point, we just don't have any, for lack of a better description, way to comply, at least with the reporting related to this.
All right, gentlemen. Well, we got about 5 minutes left, and we're at the point where I'd like to just go around the table, so to speak, and if you guys could each just give a few minutes to close us out. Start with you, Steve.
Sure, I have to. One, I want to say thank you to Gary and Capital Times for having us on. Thank you to Roy and Lee. You guys are both well revered and very busy individuals. So taking the time to jump on this panel is always fun to participate with you guys. I think that this has been a really fun conversation in that it really does get down to the crux of democracy. And we look at individuals' abilities and liberties to practice free speech. Our ability to be on this call right now and have this discussion is a result of free speech itself and the U.S. Constitution. So I think we need to be very weary of any time that we are running laws that impede that free speech. Free speech is expansive. Free speech affects the media. Free speech affects newspapers and radio stations. And if we start to take away those individual liberties, I think it's a very slippery slope. And I think we need to understand that this current law as it stands will begin to cut down that ability for us to speak freely. So I appreciate the time and thanks for having me on.
Thank you. And Lee?
Well, I would just encourage people to think about this academically. I understand the pejorative dark money. Dark money should be closely tied to a politician. We shouldn't consider all speech that is anonymous or associations that want to remain private on the issue side of the fence to be dark money that government has some right to compel disclosure of. And I encourage you to think historically that some of the major court decisions in this area affected liberal organizations. And so I wouldn't view it through a political lens of whether this helps Democrats or Republicans or liberals or conservatives. Both sides of the ideological spectrum have abused compulsory disclosure historically to silence speakers and ideas with which they disagreed historically. And so I would ask your viewers just to think very broadly about the importance of the First Amendment, associational and speech rights that are at stake when we start expanding compulsory disclosure into the area of issue speech.
Thank you, Lee. Roy, you got the last word.
I mean, I want to agree with what Lee just said as far as, asking viewers and Arizonans to view this very academically, right? Because I do think when we talk about things like dark money, that is something, I mean, if we have to be honest with ourselves, is used by both sides of the aisle, right? Democratic and Republican side, both utilize that modern campaign finance mechanism, over many election cycles since Citizens United. So that happens. And so to the extent that this gets implemented, it's going to affect both sides equally. So you got to look at it more from, again, like, do you agree with this kind of disclosure? Is that good for democracy or not? Or do you disagree and, believe that this is infringing upon constitutional rights? And I think that lawsuit in federal court and any subsequent lawsuits are going to be really fascinating to watch, because this does represent a real change, a significant change in Arizona campaign finance law.
And do you expect, you mentioned some of the ways that you guys are going to figure out these ambiguities. Do you think there's going to be a lot of people in court in 2024?
I don't know. I mean, that's an interesting question. I mean, never underestimate the creativity of a good lawyer, right? So, I mean, some we will be thinking about that on sort of what, again, sort of how you respond to these rules, but that could result in litigation in the future. I just don't know. It's going to be really fascinating to watch.
All right. Thank you, Roy. And we've reached the 9 o'clock, and I just want to thank our sponsor, People United for Privacy, and our panelists, Roy Herrera, Stephen Shattuck, and Lee Goodman. Thank you for coming on such an early time in the day and spending an hour of your busy time with us. And I want to thank the audience. appreciate you tuning in and supporting us, and have a good day, everybody.